Okay, we're 3 weeks away from the July 2022 bar exam, and you thought you were all set with all your final outlines. You were memorizing like crazy, and now the court comes down with rulings that fundamentally change aspects of constitutional law. So what do? Well, first of all, you don't panic because everybody's in the same boat, including the scholars who are trying to interpret what the court is doing with constitutional law. But you as a bar candidate are facing a particular problem, right? So Dr. Sakuzo and I wanted to share some of our thoughts with you. First of all, you know that it takes quite a while to put together a particular administration of the bar exam, whether we're talking about the UBE or a state-specific exam like California's. So it's entirely possible that there would be a constitutional law question scheduled for July, and the administrators don't have time to change it. I think it unlikely because we've known for a while that there were major cases coming before the court and that these rulings would come just before the July bar. So I think, and Dr. Sakuzo thinks, that lowered the probability that constitutional law would be tested, at least particularly in the areas of substantive due process and religion, First Amendment, Establishment and Free Exercise Clause. Because generally, the bar doesn't like to test something where the law has made really recent major changes. It takes a while for a question to come down the pipeline that tests those areas. Okay, but what if one appears on your bar exam? What if you get something that involves substantive due process or involves religion, Establishment Clause, Free Exercise Clause, First Amendment religion problems? Then what do? We always recommend, when there's been a major change in the law, that you analyze the way the law was up until, in this case, June 2022, and then explain to the grader that the court has just ruled in a way that pretty much fundamentally changes the analysis, no pun intended. So yeah, we've already changed our schemas. So if you're one of our power law users, if you have access to Proponics, our schemas of law, then you will see that the schema has been updated. We did that last week and the week before. We did that on the day after the ruling came out in Dobbs and in Kennedy. We also updated the video content in our power law course. But for those of you who don't use our materials, what do you need to know and how would you analyze that? Well, if it involves substantive due process, the only thing that's changed so far is that there is no longer a constitutional right to access abortion services. Now, what will change in the future, given Justice Thomas's concurring opinion, we don't know. But for now, it's in essence dicta. It is not binding. So substantive due process, not a big problem. Bars generally don't test right to abortion anyway. Religion, First Amendment religion, that's a bit more of a problem. It used to be that you would analyze under Establishment Clause by applying the Lemon test and the endorsement test. And so I would analyze those that way, the way you've studied up until now. And then I would note for the grader that as of late June 2022, Justice Alito announced a new test in place of, and that's literally his wording, in place of the Lemon test and the endorsement test. And what is that new test? Well, let me get the wording exactly right. That you would, by reference to historical practices and understandings, look at an interpretation focused on original meaning and history. Okay, what does that mean? Well, I have little guidance for you. I think nor does anyone else. It appears to mean whatever the court decides it means in terms of a very much a strict originalist view. What would the founders have considered when they put that clause in? That's really difficult to analyze. So what I would tell you, what I would suggest is that although there may have been a religion, a First Amendment religion hypothetical in some states' bar this July, I think it unlikely that you're going to see another one for quite a long while. Because think about it. If you're a law professor writing a hypothetical to test bar candidates' understanding of the Constitution, how are you going to write a hypothetical that gives enough to do a good analysis of that when we don't even really understand what the analysis would be? It's just does not seem to us to be a very fruitful topic to separate out competent from incompetent bar candidates anymore. So I think that's going to be a lower priority, lower likelihood event for a good long while. The interpretation the court did of substantive due process, of the right to abortion, is in our simplified way of looking at things quite similar in that the court announced that to be a fundamental right, there would be two categories of rights protected under the substantive due process clause. One would be any right that is guaranteed by the first 8 amendments to the Constitution. That includes Fourth Amendment, search and seizure, right? And the second category is unwritten rights that are rooted in the nation's history and tradition. And again, the way the court looks at that is with a very much an originalist kind of view of the Constitution and of our history. And it's unlikely that you'll see that on a bar exam either. So no panic. Actually, I think the court just made it simpler for bar exam purposes, less likely to get a religion hypothetical. You already were unlikely to get an abortion hypothetical. I think now you're virtually assured that the likelihood is probably the lowest of any topic in the Constitution. So that's where we stand as of now, 3 weeks out from the July 2022 bar exam. We wish you all the best on this exam, and we will be posting more.